Да?
Colleagues, good morning, or rather good afternoon, sorry. Thank you for coming. Though we have a very packed schedule and you found time to come up to us, because our roundtable will discuss the latest trends in using international law and various mechanisms in national legal systems for international M&A transactions. And though over the last 3 or 4 years, lawyers and economists considered the last period to be very difficult for all kinds of M&A deals in Russia and elsewhere, because we had problems with finances and etc. Despite the negative trends and negative drivers, the number of M&A deals is rather high. It is obvious that, taking into account the fact that a lot has been said at other roundtables about convergence of systems and influence of anti-monopoly law on M&A deals and active involvement of regulators in the economy, in particular in the time of crisis. Certainly, it tells upon the approaches to such deals and the assessment of risks on court disputes, if emerge, when they have to settle the conflicts and disputes. So this is a practically oriented subject, and I think we have food for thought and discussion, and I'd like to introduce our speakers. We have 2 presenters who are coming because they have landed recently, and co-chairman is Mark Curtis, Simmons & Simmons law firm partner, the senior lawyer of Vegas Lex company, Thomas Hornby, the director of legal department of Yeri Him company, Valery Sidnev, senior partner of the Russian office of Queen Emmanuel Law Company, Ivan Marusin, and managing director of the information portal Mergers.ru. They will all participate in our discussions, and Yuri will reflect all the changes that have taken place. We suggest having all questions that may emerge to put at the end of the session. We'll have special time for questions and answers. But if you consider a question to be important and relevant to be taken immediately, we can accept 1 or 2 questions right after the presentation. That's it as far as organization is concerned. And I'd like to give the floor to the first presenter, Mark Curtis. Mark, you have the floor.
And maybe I can just start by saying how delighted and grateful I am to be invited both to this beautiful city and also to this august gathering as well. So thank you very much for your invitation. Maybe just a word of further introduction about me. I've been a partner at Simmons & Simmons for 14 years. I am an M&A lawyer by background, as one might expect with this topic, with a particular specialisation in public M&A. During my career, I spent 2 years on secondment with the UK's Takeover Panel, which is our public M&A regulator, and been involved in a number of public M&A deals following on from that. I'm based in our London office, but I also have responsibility for managing our international corporate and commercial practice, which takes me quite regularly around our 18 offices in
Извините, пожалуйста, техническая неполадка.
What I wanted to do over the next 20 minutes or half an hour or so was really do three things from an international perspective. Firstly, just have a look at some of the fundamentals at the moment, what market conditions are like, what are the factors influencing market conditions, have a look how that's impacted on deal volumes, particular active sectors and regions. Then some words about sort of trends that we've seen in M&A post the 2008 crisis and how that's changed some of the drivers and structure of transactions. And then I'll finish off by doing something which I think is dangerous for any lawyer. Anyway, I think it's dangerous, which is to try and make some predictions about the future. I always tell my clients not to enter into commitments about the future, but nevertheless I'll finish off with a few observations as to what the outlook might be going forward. So just starting off looking at some current M&A trends. Put up here the chart showing M&A volumes over the last 6 years by quarter. You can see, I think you probably expect to see, the steep rise in transactions over the early part of that period, 2006, 2007, followed by the significant dropping off in the immediate aftermath of the 2008 crash. And then what we actually saw was, from very low levels, a steady sort of ticking up of M&A volumes through to sort of the end of Q2, Q3 last year, since when the trend has gone back into decline, I think sort of noticeably as a result of sort of sovereign debt worries in the Eurozone being a particular driver last summer and last autumn. And as I started writing this talk before the sort of the latest round of uncertainty really started, but I think the future even more uncertain given the events which have panned out in Greece in particular, and with the change of government in France over the last couple of weeks. So looking at some of the fundamentals, there are obviously some fairly major negative impacts on confidence at the moment. There's ongoing concern about macroeconomic conditions. There's been considerable amount of market volatility. There's ongoing market volatility, and there's still an issue around credit and the granting of credit and actually oiling the wheels of transactions with credit, and all of those things are leading to some fairly fundamental impacts on confidence in terms of the risk involved in doing deals, both in terms of valuations, being certain about valuations, and also to the risk of successful deal execution. And those, I think, are the biggest factors, although actually if you look at the situation, there are many fundamental drivers which are in place which should be strong supporters of M&A activity. We've got generally, I think, low gearing levels, corporates in general holding plenty of cash and being cash rich. There are several sectors, for example, chemical technology, financials, under pressure to consolidate for one reason or another, and you've had continued strong commodity prices and competition for and demand for natural resources, which again have been deal drivers as well. But, and I think there is a but, that uncertainty, the focus on regulatory scrutiny, regulatory intervention, also knocks confidence. I think there are a number of shareholder concerns generally as well. We've seen situations, and I'll come on to say a little bit more about this later, but seen situations where shareholders have questioned deals, voted down deals, which means that for CEOs actually looking to do deals, there's a fundamental uncertainty there as to how their shareholders will react to them. I think those things make proper due diligence, proper acquisition planning and integration and the ability to communicate those things even more important. Now those last factors, proper due diligence, proper planning, proper integration, ability to communicate all of that, none of those themselves are unusual or shouldn't apply at any time, but I think in the environment that we've got with fundamental uncertainties around, they just create greater uncertainty and quite greater focus in the current climate. Now just turning to have a look at some of the active areas over the next couple of slides. The first one is looking at regional M&A volumes just last year and this year. You can see probably again what you'd expect to see, Europe and North America forming the largest proportion, although healthy amount of deals in the Asia Pacific region and Central and South America, and also notably to the Middle East and Africa appearing on that chart as well. And you can see that there's quite a degree of consistency in the 2012 figures are only Q1, but there's quite a deal of consistency between what the picture was for the whole of last year and the Q1 position for this year. Looking at it slightly differently on the next slide, which addresses M&A volumes by sector. Probably difficult to make out from the floor the numbers here, but what you see sort of reading round from the sort of 1 o'clock position, 1 or 2 o'clock position top right, is industry and chemicals 20.2%. I'm looking at the 2011 figures, the numbers on the right now. Consumer 13.4%, business services 12.5%, telecoms and media 15%, energy, mining, utilities 9%, which I must admit I was quite surprised when I saw that. I would have expected that to have been larger. Financial services 8.7%. Then the last two, pharma, medical and biotech at about 10 o'clock, 7.8%, and the others accounting for 13.3%. Looking at Q1 of this year, you'll see the position is slightly different just based on the first 3 months data, where the predominant sector is the energy, mining and utilities sector, which I think is more what one would expect, and that perhaps reflects what I was saying about confidence. You have very particular factors in that sector in terms of commodity prices, demand for resources, driving activity in a quarter where otherwise M&A activity was on the decline, and perhaps that impact on confidence affecting deal doing in other sectors where there aren't those sort of specific factors that relate to the resources sector. So just to try and draw some thoughts and some themes out from that data. As I said, you see energy, mining and utilities sector strengthened their dominance of activity across regions. In North America, South America as well actually, Europe and APAC. But we are seeing M&A from high growth markets into Europe. And I think that has generally been a growing theme over the period since 2008, perhaps a slight slowdown in that in 2011. But there's no doubt that the deal flow from the high growth markets into developed economies of Europe and North America is a considerable factor, with companies looking to acquire market positions, looking to acquire technology, looking to acquire IP. and you see some of that in some of the, the big deals that have been done. For example, Three Gorges acquisition of Energias de Portugal, which was $3.5 billion, Chinese company acquiring in Portugal. Sinopec's acquisition of Daylight Energy in Canada, $2.1 billion, really significant sized transactions from high growth and emerging markets into developed economies. And I think a feature of that as well has also been, and you can see that in the growing willingness of companies from those jurisdictions actually to get involved in situations and sort of put their heads above the parapet in getting involved in situations in a way that perhaps they might have been more historically reticent to do. And a couple of examples of that in the London market context. In 2010, we saw the Korean National Oil Company making a hostile bid for Dana Petroleum. Now, getting into the sphere of hostile takeovers and the publicity and the controversy that can sometimes get with that, I think is something that historically acquirers from high growth markets have been less willing to countenance and get involved with. And similarly, at the moment, there's an ongoing auction for Cove Energy PLC, listed oil and gas exploration company with assets in Africa, listed in London. And you see there the willingness of companies, again, from Asia, from high growth markets, to get into a competing situation and very publicly to compete for the asset with the likes of Shell. Companies such as PTT, ONGC Videsh, very publicly competing with that asset. I think that's a new factor. We also see the continuing desire of companies in the developed economies to invest in the high growth markets and looking for acquisition in high growth markets as they seek to compete and to increase their competitive position. I think that is likely to continue. And another interesting factor is the continued growth in M&A deals between high growth markets. For example, activity investing in Africa by companies from China and elsewhere. And I think in Africa, technology and particularly telecoms and the growth of that market is a particular driver at the moment, which is giving rise to some ongoing consolidation and deal activity. So I think the bottom line from all of that is that high growth markets are very much here to stay, very much a new driver for M&A activity, although increasingly less new. But I think that is a feature and a trend that we are likely to see continue, or that we will see continue as the M&A market becomes completely global. And therefore, if you actually look at the stats and some of the deals that are going on, you can see the cross-border, regional and sector opportunities that do exist and are drivers for that activity, if only some of that lack of confidence can be overcome. So just moving on to the next part of my talk, and what sort of trends have we seen since the 2008 crisis? I talked about high growth markets, that is important, but that doesn't reflect the whole story. And there are a number of other trends that I think we have seen impact on deal activity and on deal drivers and the way that deals are done, and some specific examples of that. I mentioned in my introduction the role of credit and the ongoing difficulties with credit, and I think that is still a significant drag on activity, particularly in the developed markets, where companies, private equity houses, are reliant on banks to fund transactions, and that credit for acquisitions really hasn't been there. I think we haven't really seen any big deals financed by syndicated acquisition finance, that is quite difficult to do. And certainly in our practice, we see sort of the symptoms of this and the signs of this on a day-to-day basis. Giving you sort of a couple of examples of that, a number of deals recently, we have seen deals which have been structured not with new finance to finance the acquisition and the working capital requirements of the target, but to see the extension of the target company's existing financing facilities. I think for two reasons. One, because of the difficulties of getting credit, and secondly, pricing-wise, sometimes be easier to roll over and continue existing facilities than trying to enter into new facilities at a time when banks have got funding difficulties. We've also seen, as another example, difficulties with financial close, difficulties in achieving financial close. In one case, we've seen significant delays in deals actually being completed after the contracts have been signed because of the problems of getting debt syndicated in even quite small cases, and acquirers having to finance transactions in other ways. I think one of the features, though, of that difficulty in getting credit is that it has strengthened the hand of strategic buyers. One goes back to the days of 2006, 2007, when much deal activity was driven by financial sponsors. There was a case that many corporates found that it was actually difficult to secure and do deals because in pricing terms they were struggling to compete with financial buyers. That position, I think, has now reversed, where it is actually now much easier for strategic corporate buyers to win assets. The other feature relating to credit is talking specifically about private equity funds. I think much has been said about sort of the private equity industry having a lot of capital committed. I think that is undoubtedly the case. But because of the difficulties with leverage, that still has made deals difficult to execute and to close, because lenders are insisting on a much higher proportion of equity finance. Leverage is generally smaller, high proportions of equity, and therefore private equity houses having to put more equity capital in, which again makes the larger transactions more difficult to execute. Another trend we've seen is distressed sales. I mean, not surprisingly at a time of economic difficulty, but clearly distressed sales are a feature of the current market. And I wanted to say a little bit more about shareholder scrutiny. Again, I referred to this earlier, but I think it's a difficult situation for CEOs to do transactions when they don't actually know how their shareholders are going to react to that. A very highly public example of that was the Prudential, which was looking to do a big acquisition in China. Deal negotiated, executed, announced, and shareholders ultimately didn't approve it. And given all the other uncertainties that are going on, that makes life very hard actually to go out with a transaction unless you're absolutely sure of the reaction of shareholders to it. At the moment, within London, we've got what's called the shareholder spring going on, which isn't directly related to M&A, but is related to executives' remuneration. And underlying all that is criticism that executives are being over-remunerated for underperformance of their companies. So on the one hand, they're being criticised for that. On the other hand, they're not sure as to how deals are going to be received when they do actually try to do deals. Again, looking at the overall environment, that is just another uncertain factor. Regulatory change is also something that I should mention. It's obviously the topic of much debate at the moment. There is ongoing much regulatory change, and the regulators themselves are changing deal dynamic. For example of that, a very specific example of that, the UK Takeover Panel changed its rules last year in the light of criticism of a hostile bid by Kraft from the US for Cadbury, a British chocolate manufacturer. Very highly politicised, very controversial, and in light of that, the Takeover Panel has changed its rules because of a perceived feeling that in the context of a hostile takeover, all of the cards were stacked in the hands of the bidder, the hostile bidder, and that target companies were at the mercy of capricious acquirers. And that dynamic has now been completely reversed, so that all the hands and the cards of the target company, with requirements to announce the identity of the offeror, to name them at an early stage with limited periods to negotiate deals, limitations or prohibitions on break fees. And you can see that sort of dynamic makes it a lot more difficult, actually, for an acquirer to do a transaction. We're also seeing regulators having to think about issues which perhaps historically they haven't had to think about. And one particular example of that is how they come to look at state-owned enterprises and how they come to regard state-owned enterprises in the context of an M&A transaction, both in the context of antitrust law, when in evaluating market shares, we're seeing, for example, the EC Commission having to work out whether a state-owned enterprise's market share needs to be consolidated with other state-owned enterprises from the same country. And you'll see that we've seen the Takeover Panel grapple with the same issues to actually try and work out how one state-owned entity is related to another state-owned entity for the purposes of acting in concert type rules. And I think the regulators are still finding their way with those issues. It happens that the EC hasn't yet found one entity to be connected with another for antitrust purposes, but it's clearly considering the question very carefully. And likewise, that's something that's on the Takeover Panel's radar screen. And another word just about regulatory change. I mean, it's not just in that I talk about the EC, I talk about the Takeover Panel in London, but it's not just these regulators. It's regulators worldwide, of course in the US, but also in the high-growth economies themselves, as antitrust law develops, anti-monopoly law develops, and those regulatory hurdles become very real constraints in those jurisdictions as well. Another trend I just wanted to highlight was the fact that what are the drivers for outbound M&A from the high-growth markets? It's not just resource-driven, it's not just commodity-driven. I think as we see a number of economies seeking to shift from and change to a more consumer-led economy, that in itself is a driver, which means that, that access to technology, access to IP rights become important drivers and reflection of the economic change within those economies themselves. And again, I think that gives rise to some interesting questions around the execution of those transactions and expectations from those transactions and how they are managed. So I think it very much does remain a dynamic environment. Things are changing and trends have changed significantly to reflect the realities of the post-crisis market. And I'm sure that those realities are the new norm. So what about the impact on the structure of transactions? I think, and wary of making gross overgeneralizations, I think it is very much a buyer's market. I put here love your buyer. I'm conscious that could actually mean love your seller. I'll say a little bit more about that in a minute. But what I mean by love your buyer is that because of the general nervousness and difficulties for acquirers, it means there aren't so many of them, So if you're a seller, there might not be so many natural buyers. So those that you can find if you're looking to sell, you have to look after. And I think we've seen the impact on that in auction processes where sellers are being more realistic, certainly in terms of price, but also more realistic in terms of the terms that they can expect to achieve and sort of markups of agreements and contractual provisions that they assess buyers on. But I'm conscious, in certain circumstances, it's not all about the buyer. It may mean you may need to love your seller as well. There are maybe some sellers who have a very strong position, may be reluctant to sell in current conditions, current valuations, may have other alternatives, for example, spin-offs, etc., other ways of realising value. So if you're a buyer looking for a particular asset, it could be actually that the boot is on the other foot and you need to look after your seller very carefully. Minimising execution risk. Clearly, a factory, you get a deal to the table, want to make sure that that deal gets executed, gets completed. That's had a number of knock-on effects. I think we've seen less hostile deals, certainly outside the US anyway, less hostile transactions where there is more inherent uncertainty about the completion of the transaction, and a number of contractual terms and provisions which people are looking at to make sure that deals go through. Some very specific examples of that, for example, in the context of that impacts on material adverse change clauses, the sort of things that go into material adverse change clauses. We're now commonly seeing material adverse change clauses relating to countries leaving the Eurozone, relating to if bank lenders are forced to recapitalise as a result of the Eurozone crisis. We're even seeing this flow through into the way that the euro is defined in agreements, and very often now commonly seeing the euro being defined as the currency in circulation in a specific country, most commonly Germany, than just generally being the euro. Cash, I think, remains the preferred form of consideration because of the volatility around share price and shareholder reaction to transactions, and a much greater emphasis on defining the efforts which both parties to an agreement need to take to get regulatory approvals for the deals. And in some circumstances, and most circumstances, obviously the importance of break fees, no shop agreements. I say in some circumstances because all of those things have just rather frustratingly been banned in the UK, but I think as a general tool to make sure that deals happen, they still have a relevant, very real and relevant role to play in cross-border M&A. Dealing with regulatory concerns is another thing. The importance of having a dialogue with regulators, the importance of working out what the implications are of connected entities for antitrust regulation, for takeover regulation. These are things which become important to manage the regulatory risk. And the importance of integration and actually looking ahead of the deal as to how important integration is going to be, both to realise efficiencies and to achieve objectives of the transaction, and that's going to flow through into due diligence. And then the cross-border issues that I referred to on the previous slide in terms of, particularly in the high growth and developed markets, if the aim is to access technology and IP, what do you need to include in your deal terms and actually in the way that you're going to identify issues and the way that you're going to integrate the deal to actually make sure that you can have access to the things that you thought you were having access to. So I think there are certainly changes in deal structures which reflect changes both in the short term but ongoing in the sort of the long term economic realities of the situation as we will see it going forward. Just to touch very specifically on that post-merger integration point, given the criticisms, some of the criticisms from shareholders as to the rationale for deals, whether they represent good value for shareholders, whether CEOs are going to be subject to criticism for doing them, there's a very real requirement for a focus on post-merger integration and securing maximum value from M&A and communicating that. That means due diligence in the pre-merger phase is going to be increasingly, it's always been important, but I think the way it is done is going to be increasingly important to identify material post-merger issues and allow to follow through into the post-merger integration, for example, in relation to HR issues, pensions issues, staff issues, employment law issues as well. And I think Tom's going to say a few more words about due diligence in the Russian context. So that's some of the trends I see. Just to finish off with a few brief words on the future. As I said at the start, always a dangerous thing to do, but maybe just to leave you with one or two takeaway thoughts and predictions, really as a summing up of what I've been saying over the last half an hour or so. I think corporate search for growth outside of their home markets to improve their competitive position, to have global access to resources, markets, advisors, shareholders, investors, is going to continue to feed high growth markets. I think scrutiny over M&A deals and requirement to justify M&A deals, not just to regulators but to shareholders, is here to stay, and actually is going to be a driver for M&A as well over the medium term, not just keeping regulators happy in terms of deal structures, but actually regulation driving deals, for example, in the financial institution sector, the impact of regulation, regulatory changes, driving needs to strengthen, reinforce balance sheet and driving M&A itself. Integration, project planning, due diligence can continue to be very important and increase the chances for successful merger and acquisition. And I think that's going to be true in a much wider sense than just focusing on financing and legal issues, trying to roll the whole piece forward to look at the underlying aims of transactions. And with corporates holding cash and at the same time feeling risk averse, there are going to be counteracting pressures in the medium term between the desire to strengthen the core business and competitive pressure on the one hand against the economic uncertainties that we face at the moment. So as a final point, I think my final view is, perhaps not surprisingly, that the outlook is fairly mixed, but over a longer term, the fundamentals actually point to a much stronger long-term scenario.
Спасибо большое, Марк, за очень содержательный.
Thank you very much, Mark, for your very interesting and rich presentation. I just want to ask you one question in order to make the discussion action more interesting, because we're at a legal forum, taking into account the market changes. Taking into account the market changes, taking into account that the number of deals is going down, it seems that the lawyers in these deals quite an important mechanism of risk management, and the lawyers should reassess their role and think even more and more how to influence more positively on transactions and deals, because the number of deals is not really great and the situation in the market is quite complicated. Did you have in your experience a position or an opinion that it is needed to search for ways how to conclude deals, even in a complicated financial situation, even in a situation when the party is unable to accept the risks out of the deal? Do you have any legal mechanism for it? And do you have any examples of what you managed to do in this area in the last years? Or is it a question of future, the reassessment of a lawyer's role in the deal?
Well, I think you're absolutely right what you say about the lawyer's role. I think in terms of, I'm not sure if it's a reassessment of that role, but I think it is. You're right to say that it is extremely important that lawyers are able to think creatively, actually to identify those risks and how to overcome those risks for clients. I mean, I think one specific example that I might just highlight, one thing we have seen is actually the role of warranty and indemnity insurance in the context of M&A transactions, where you have a mismatch between the demands of a buyer to be protected against risks through warranties and indemnities on the one hand, and on the other hand, a reluctance of a seller actually to give those warranties and indemnities and expose themselves to ongoing liability in those. And we've actually seen the growth of specific insurance products whereby, no doubt for the payment of a healthy premium, the insurance company will come in and stand behind warranties and indemnities so that the buyer has got a right of recourse, but the seller knows at the time that they are closing the transaction, they are getting a clean break. And I think it's those sorts of mechanisms which are looking at the risk sharing between the parties and how that might be allocated in slightly different ways that are going to be a feature that we all need to think about going forward.
Thank you very much. Now I'd like to give the floor to the second speaker, to Thomas Hornby from Vegas Lex Legal Company. Good afternoon, dear ladies and gentlemen. I'm all very happy to be here in St. Petersburg. It's a very good city with a beautiful weather. Unfortunately, my Russian teacher said if you are going to talk about the British law, it's better to speak English.
Start my thoughts on English and Russian law in the context of cross-border transactions and make a few observations. I thought Mark gave an excellent introduction, in particular to the surrounding macroeconomics and some of the trends that we're seeing now and some potential trends that we'll see in the future. By way of introduction, my background, I trained with an international law firm in the UK, but in the last few years I've been focusing on cross-border transactions involving Russian assets. And I know that today there has been in one of the other halls a session on professional ethics. So if I may, I'll start by declaring an interest. And my interest is that I've lived in Russia for 5 years and I thoroughly enjoy it. And I hope that there is a room for English lawyers for some time to come. If we look at what's happened in Russia, since the 1990s and the opening up of the Soviet Union, there's been, one might say, an invasion of common law lawyers, particularly in Moscow. And it's worth taking some time to try and establish the reasons for that, whether it's right to do your deals under contracts governed by English law, and perhaps to have as the forum for dispute resolution the London Court of International Arbitration, whether or not the developments in Russian law that my Russian colleagues can say something about is going to change the balance, is going to change the way that we do deals in Russia, and some lessons for the future. Now, I'd start by talking about perhaps a typical private company acquisition involving Russian assets, which might involve, for example, a seller in the BVI, sorry, in the British Virgin Islands, selling a Cypriot target company that owns a Russian company that holds Russian assets. And with a contract under English law where in the event of disputes, those disputes will be resolved by arbitration under the rules of the London Court of International Arbitration. That might be a typical private company acquisition that an English lawyer normally sitting in Moscow might be asked to advise on. Now, in some sense, it's a false choice because, as we'll see later, I think lawyers have to remember that they're in the risk management business. And as I think, Mark, you were referring to different products, for example, insurance products, that one might use in order to manage the risk associated with acquiring a company and the liabilities that are attached to that company. And so, why is it that there was this, I described it as an invasion of English lawyers, and I would say all the usual suspects came into town. The large English commercial law practices, some of the big American practices. What was it about common law which perhaps allowed that to happen? And one was that, for example, with English law, English case law has been for hundreds and hundreds of years. So there's a sense of certainty in that you know what you're getting. If there's a breach of contract, if there's a breach of warranty, for example, the leading case on assessment of damage is still a 19th century case. So Russian businessmen had some idea about the form of contractual recourse that they would have in the event that their assets were worth less than they were expecting, and they suffered loss. Another factor that English lawyers sometimes refer to as being a reason why one might consider structuring your transactions under English law is that the law evolves quite quickly in the sense that there is the concept of case law, and judges can make decisions which are subsequently legally binding precedent for future decisions on similar facts, which allows the law to evolve relatively quickly with respect to the needs of businesses. One other reason one might refer to is the objectivity. You could say if you have, for example, a Swiss seller or a Russian seller and a Swiss purchaser, and you're discussing where you should go in the event there's a dispute, you might say, well, why not London? And there would be good reasons for suggesting London. You could say, well, it's impartial. It's neither Switzerland nor Russia. It's somewhere with an established legal system. It's arguably one of the leading banking centres of the world. There are experts to hand. There is a lot to be said for London. And also, there seems to be a sense that Russians have found London a nice place to live. There's some sort of cultural affinity. Russians go there on holiday. Another reason is the flexibility or the principle of freedom of contract that applies largely under the common law. And parties to a contract are, with certain exceptions, capable of agreeing the detailed terms of their commercial bargain. That's very helpful. It tends to result in large documents, but it allows the parties to know, before they go into the deal, exactly what will happen in certain circumstances. And there are exceptions. I mentioned sorry, just went ahead of myself, I apologize. There are exceptions such as restrictive covenants. Parties cannot agree to restrictions. For example, if you have a seller selling if you have an owner-managed business, you may want, if you're a purchaser, to restrict the seller from competing with the business following the acquisition. It's therefore very important to try and agree in that situation some fair and reasonable enforceable restrictive covenants. You can't agree restrictive covenants, for example, over the whole of Russia with respect to a large variety of different services, because that wouldn't be seen as reasonable. Another one is, which we come across quite a lot, is penalty clauses, and there's this concept in English law of liquidated damages, and the idea being that parties cannot agree that in the event that a particular circumstance arises, that the party in breach of the agreement will pay a sum of money which is out of proportion to the losses that the innocent party would suffer. So there are limitations on this principle of freedom of contract, but nevertheless, I think in the context of cross-border transactions, there has been some appetite to use English law because it is perceived to be a jurisdiction where you can agree the fundamental and detailed terms of your commercial agreement without too much supervening local law. Now, typically the example that people give in the context of acquisitions of Russian assets and the benefits of using English law is this concept of representations and warranties, and the benefits for a buyer of having a schedule of representations, a list of promises about the business. And there are technical differences about the remedies that are available for breach of representation and breach of warranty. But the point that I'd like to make is that the measure of damages, for example, for breach of warranty is established by case law, and likewise the English lawyers will have an idea what the measure of damages are that are recoverable for breach of representation. Similarly, there are instruments that have been tried and tested in the English courts, such as put and call options, which are very helpful. The idea that in the event of a dispute, for example, one party can require the other side to buy the party's shares, or can call upon his counterparty to sell his shares if he breaches the agreement. In the context of a shareholders' agreement, these instruments are very helpful, and although I understand that Russian law, there have been some recent developments in Russian law to try and approximate put options, call options, there hasn't been the court practice yet, as I understand, which will give some businessmen sufficient confidence and certainty that the instruments that they've agreed to in the document will actually be enforced by the Russian courts. So some of this I think I've said already. Arguably it's the financial capital of the world. It's a well-established centre for dispute resolution, and there's access to experts. But as I said at the start, I think it's a false choice to say English law or Russian law. We have to remember that as lawyers, we're assisting businessmen. And we're assisting businessmen who often have a great deal of experience and made a great deal of money and understands the risks associated with their businesses. So when the question is English or Russian law, the answer may be, in certain circumstances, English law, but not all the time. And my point here is quite simple, that for all the advantages of English law, the costs of enforcement are very large. So even with a super agreement, with some put options and call options and reps and warranties, I would say the due diligence part of the business acquisition is by far the more important part. Effective, and Mark, you alluded to this before, effective commercial and legal due diligence should result in a buyer acquiring an asset instead of acquiring, unfortunately, as sometimes is the case, a lawsuit. So there are some other points which I'd like to make about English legal documents. And one is that, obviously, for a Russian, for example, for a Russian purchaser, they will sometimes ask a question, why should we use these long-winded English legal documents when in the past we've bought businesses, we've agreed on a very informal basis, we've made a lot of money, we're very successful, why should we bother using English law? And actually, I sometimes struggle to answer that question when you're faced with a successful Russian businessman. And of course, there is the time and the cost of enforcement, which I referred to before. I mean, London lawyers are very expensive. And once you get into a dispute, you can't just pull out. So, if I have one message from this talk, it's the importance of due diligence, and I could perhaps make that point best with referring, this is a cross-border example here of a cross-border dispute. Now this is a dispute in the courts, and of course with Russian assets you'd usually have a London Court of International Arbitration dispute resolution clause. But actually, when you get to the trial part of that slide, and you compare the costs of a trial with the costs of, for example, resolving a dispute in arbitration, the costs in arbitration can actually be even more because you have to pay for your arbitrators. I think, and this comes with a health warning, because I'm not a disputes lawyer, I think the standard rate for an arbitrator is £450 a day. So let's say you have 3 arbitrators. You've got to pay for the arbitrators, you've got to pay for the rooms, you've got to pay for your lawyers. Very expensive process. Sorry? There's a day per day, is it? A cap of 450 an hour. Yeah, for your arbitrators. So we're seeing in Russia some developments in the Russian law. Russian shareholders agreements, for example, you can have a shareholders agreement under Russian law, and we're seeing increasing appetite among our clients for Russian law shareholders agreements. There is some reluctance among especially those Russian businessmen who've done deals under English law in the past to use Russian instruments, and we can understand that. But we're also seeing some clients who are saying, for example, where they have a Russian seller, well, we'd like to do our deal under English law, we're familiar with English law, but the Russian seller won't have it. So maybe we'll have a Russian law-governed sale and purchase agreement, and then we will have representations and warranties, some of the advantages of the English legal document, put into a separate deed of warranty and undertaking. There is an advantage to that in the sense that it can be rather, for Russian businessmen looking at an English law sale and purchase agreement of, let's say, 150 pages, there is a risk that some of the warranties in there require a great deal of negotiation, a great deal of time is discussed negotiating it between the lawyers. But if the warranties are covering areas of risk that are not a real risk for the business, it will please neither the seller nor the buyer, because there is a lot of discussion which they consider to be irrelevant. So I think one of the trends for the future is that as lawyers, we must improve our listening skills, and we must try to understand, if we're acting for a purchaser, what the real risks are as seen by the purchaser. So I think we're going to see, going forward, more focus on due diligence exercise, a more commercial approach. due diligence reports have to be written in a simple way that the buyer can understand, with more robust conclusions. And deals and the legal process, it isn't a process where you go 1, 2, 3, 4, follow the same method every time. There is no one-size-fits-all for any transaction, and the lawyers should focus as much as possible on covering off in the legal documentation the real areas of risk associated with the business. So, and Mark mentioned this before, the role of insurance, I think, for mitigating risk on deals is going to become more important on cross-border transactions. In London, there is both for sales of assets, sales of businesses. It's possible to have for the seller to take out insurance, but also for the buyer to take out insurance, because typically in a negotiated sale and purchase agreement, the seller will agree to caps on his liability with respect, for example, to the aggregate amount for which he will be liable in the event of a claim under the agreement, or the time period in which any claims can be made. And by having insurance, it can allow the buyer to recover losses over and above the caps that have been agreed in the document. For a seller, well, the buyer, in fact, may insist that the seller takes out insurance because the seller's a credit risk. The seller can be confident that the seller can be confident that it can pay out if there are any risks that come back and haunt the seller. So there's that concept of insurance, which Mark discussed earlier, I think will become more important in the context of acquisitions involving Russian assets, and I think that the insurance industry in Russia may soon start developing more sophisticated products and perhaps get involved in the M&A market. Other points to note going forward, I think we're going to see more pressure on law firms to be efficient, more pressure for lawyers to provide fixed fees for deals. The years of billing all the time that you spend on a deal, I think are gone. I think clients now are under increasing pressure, and I think that new models for billing structures, Mark, you know a few things to say on that, will become more widespread. In Russia, the big international law firms, the English law firms in particular, are very Moscow-centric. I think that we're going to see more increasingly lawyers are going to be looking to do deals where the assets are in the regions and where the clients are in the regions, and less focused solely on Moscow. And I think that I hope that we're going to see shorter, more focused documents from English lawyers, where the documents are concentrating on the real risks. And that, I think, concludes the observations that I'd make on the Russian and English law, but I'd be absolutely delighted if you have questions or.
Большое спасибо, Томас, за презентацию.
Thank you, Thomas, for your presentation. And I'd like the next presenter to speak, who is Valery Sidner, who is the director of the legal department of Evro-Kim company. Thank you, Alexander. Well, I'd like, first of all, to support what Mark Curtis said, as far as trends in M&A deals are concerned, there is a trend, that's true, and Mark emphasized it, that the chemical sector is moving towards consolidation. And I'm representing a chemical company, a major chemical company producing mineral fertilizers in Europe. Also, I'm a major European producer, and I can confirm it that the process of consolidation is underway, and we are very active in it, and we are increasing the trend because we've just closed a major deal in chemical sector, buying out in BASF company a plant for producing fertilizers in Antwerp, value more than 1 billion euros, or a multi-million euro deal. And I think that this approach is correct in terms of reorientation of lawyers' work involved in M&A deals. That's what Mark said. So there should be no short-sightedness. The work should be expanded, and they should work based on their concern about further behavior of the assets within the group. And we decided to track each particular aspect because we understand that we are buying assets which consist not only of money or property, but also of human resources, and that the packages we acquire are very much different from what we have in the Russian market. That is why Mark was correct saying that post-merger issues are of utmost importance, and lawyers should monitor them. As far as general concepts of Russian law are concerned, I see here a lot of practitioners, and they are aware of the fact that Dmitry Medvedev in early April submitted to this parliament a package of amendments to the civil code which change conceptually numerous aspects of civil law, including those which relate to subsequent deals like M&A deals. And I think that we'd better discuss the issues which, in the perspective of a practicing lawyer, involves Russian and foreign law. The trend consisting in using for requiring foreign assets consists in using the law of the country of residence of the assets, that is foreign law. But they're very, very much scrutinizing the buyer because the seller realizes that he will have to work with the buyer for a long time after the deal. So when we acquire assets in Antwerp, we use Belgian law for our agreements. Now we are acquiring a German company. We use German law for this. And thus, we are not in the accepted concept, and the Russian lawyers are involved in deals which use English law only. No, that is not true. And those mergers and acquisitions that will take place in Russia will be based on Russian law, which is very clear for us. But we do understand that without knowing the principles of common law countries, but also of the entire world, of Americas, Europe, Asia, so that is a must. We cannot go without it. And I'm thankful to Mr. Medvedev as a practicing lawyer that he has come up with the initiative to change the civil code in order to bring it into compliance with the widely accepted norms and standards. Also, there are Russian legal firms like Vegas Lex, EPAM, Mr. Gorodzitsky, Al-Rut, Mr. Pepelaev and colleagues who spent a lot of times working on the amendments in order to have a well-cut package of amendments. Certainly, we succeeded not everywhere, but these are just first steps. We are young enough, and I think that we'll live to see that we will have deals in Russia based on Russian law sometime in the future. So, irreversible warranty. We know that the guarantees or warranties under the Russian law may have a term of no more than 3 years. They may be revoked, and if there's a new law, for a new directive, for example, he can change everything. And how can we work with the M&A deals with a foreign investor? Because he must be confident that in any case he will be part of the asset. And EBRD and others, they always require the guarantees and warranties which they can use under the English law, and they can use it in order to sign the assignment agreement or the right of irrevocable guarantee and so on in order to protect his company fully. So this concept of irrevocable guarantee, if introduced in Russian law, will certainly facilitate deals under the Russian law. The concept of independent warranty is vital because the civil code had a trustee guarantee, but there was no independence guarantee, which is a basis. Because if surety is linked to guarantee and there's no basic warranty, then any M&A deal will imply paying money or exchange of certain assets. Someone should guarantee the sufficient amount of money. You cannot always go to the bank and get a banking warranty because it's expensive, and not each and every bank will work with the risks here in this country. And without using the institution of guarantee or warranty, we won't be confident enough. Now, we can guarantee to third parties the fulfillment of our liabilities, be it financial or other. Now we have a concept of warranty mentioned by Tom Hornby. That is what we lacked, because a warranty is a guarantee. Warranty and guarantee under English law are different instruments, but in Russian law they were non-existent with the exception of bank warranty. Now we are going to have both warranty and guarantee, and I'm happy about it. Certainly, we will get a concept of assurance of representation or breach of the contract under English law. And the buyer can go to court and sue for damages. And he can demand going back to the initial stage of the deal. I have never witnessed an attempt by our colleagues to introduce in any kind of contract or agreement regulated by Russian law this notion of representation, but I have met judges who considered it a declaration without any legal force, and they were absolutely useless. Now, with the introduction of representations, the way they exist in the draft considered by the State Duma, we can develop this instrument and we can start developing law enforcement practice. And creating case law, we should not get the ship drowned, so to say. The difference between the Russian jurisprudence and any other, we can always try to destroy what's contained in the law. We remember the Megaphone deal case, the Megaphone case, which killed in the bud the concept of agreements in Russia, though neither the civil code nor any other law prohibited using shareholders' agreements. But the so-called smart lawyers bringing suit to court, they killed this concept for many years to come. So they actually killed the instruments for many years to come. And thanks to titanic efforts of the legal community, and in the first place by the president, we came to realize that the shareholders' agreements are covered now by Russian law, and they are desirable even, and now we can conclude such agreements under Russian law. Another point is a very weak and undeveloped, even illusionary institution of indemnity. This is related to contract liabilities. In English law, this instrument is one of the strongest as far as defense is concerned. If parties have recognized the indemnity and specified it in their contract, the other party can first pay out or cover the damages, reimburse the damages, and then they may get them back going to court, through court. We did not have such a possibility before. I participated in 2 court proceedings myself, and we tried using the instrument which we set up in Asia, and we tried to have the decision of the court in our favor, but we failed. And now this goes for debtors and creditors the same way, and I hope that it will be applied if we succeed in creating case law, and then we will be using the indemnity institution specified in agreements by the parties in purchase and sale agreements or in any other contracts. Another thing to mention is the introduction of different types of contracts. We used to have a principle of freedom of contract, but courts considered most norms as dispositionary and not imperative. And we had a lot of court precedents, so-called precedents, when the court recognized that the norm was imperative, thus killing in the bud very good initiatives. So we did not have a chance for any framework agreements. We have no M&A deal, and I've been practicing law for 21 years, and actually in all major M&A deals there's always a kind of a framework agreement, whatever you call it, term sheet, framework agreement, anything. This is an agreement which has no major subject, but which prescribes the details for further contracts or agreements to come. And I have seen a lot of court decisions which did not recognize framework agreements. And though these framework agreements specify not only the conditions for merger, for financing, but a lot of preliminary steps to be taken, due diligence in particular, valuation, and etc., but the court did not take it into consideration whatsoever. Thus, doing away with this approach, the court actually made us go to the English law, and we saw very bad instruments which we used under English law, which, for example, prescribed purchase and sale agreement under Russian law, but financed by Swiss law, because the major funding came from Switzerland and so on. I hope that with the introduction of new legal instruments, we will have fewer problems. And last but not least is the auction agreement, which was mentioned by Tom. Put and call agreements within the shareholders agreement or option agreement as a separate subject of legal relationship. You know that under Russian law we had only issuer option. It was a security, but it did not disclose what we actually wanted to see in M&A deals. And the introduction of this new instrument will change the situation, I hope, because it will somehow facilitate the movement of capital throughout Russia. If we have option agreements concluded here, then it will make our assets more efficient in the Russian market or in other markets if the deals are concluded in the Russian territory between Russian issuers of securities. And this is work for our home laws, because it will certainly improve capitalization of their companies, and for external consultants, because a lot is to be done, though it is a simple thing. But I have never seen similar options, because each time it's different, because there are different time frames, different costs, different formula, and different understanding of beneficiaries for those who are selling or buying. And this is an extremely interesting field for practitioners.
And I also wish you all to get this tool in your hands and work with it and be happy. And the last thing I would like to tell you, it's actually the escrow contract. I'm very happy about it because it's a movement within Russia. We were not able to open escrow accounts at Russian banks because there was a certain ban working in Russia for Russian transactions within the Russian legislation. We had to go to the Russian bank subsidiaries in abroad or even to international banks to open escrow bank. So certainly we had a concept of a letter of credit concept. We also had bank sales and so on, but I cannot imagine a bank sale. If you want to purchase an asset for $1 billion, it should be probably a room with a similar size of this one. How we can also deliver so many cash into a room and carry out such as transactions, so that we had to feed the international banks and use international law. Now we can open escrow accounts at Russian banks. It will give an additional business to Russian banks, what is quite good, as I think. Also, we will have some lawyers working with these transactions, and the customer, the clients will find it easier to carry out these transactions because they don't need to bring money abroad with going through the currency exchange control and financial monitoring. I think it's quite good because I also represent a quite a big company, but all these amendments and I really like them because most of these amendments can be characterized as the detailed freedom of contract, because the principle of freedom of contract exists and works. But as I already said, many legal provisions became imperative ones within the practice or after the court practice. We all also understand that the change of the civil legislation is in favor of the participants of the legal relationships, but as a lawyer, I understand it will also give us an additional opportunity to prove our position in court, because we do have this imperative position and we can also carry out these transactions in Russia and based on the Russian law. Thank you very much. Thank you, Valerie. It was a very interesting presentation. We've got 2 more presenters left, and I would like to give the floor to Ivan Marisin. He is the partner of Queen Emmanuel legal firm. Thank you very much. Good afternoon. I apologize for joining you later than it was intended. The topic of my presentation is actually the simple way of transactions, because I'm a lawyer and I was always involved in court proceedings and commercial court proceedings. And I can also tell you my experience. There is no simple way. All the complicated transactions require also can also generate complicated disputes, and it is also needed to consider them in a very detailed way. It is what is very expensive. The next moment is the idea which way of dispute resolution is the most efficient one. I think it is more efficient to resolve a case in a related to a corporate transaction, to relate to any transaction, is just an agreement. It is easier to agree than to bring something to court. So let's agree before going to the commercial court. So let's get less ambitious. Let's try to stop and find in yourself some elements of goodwill and of ability to resolve a case before court, because we lawyers deal with the transactions when the parties are so emotional that they even don't want to hear about each other. But every time when we have a new client, the first thing we do, we also go back to it quite often when I want our client to search for an opportunity to agree, because any court proceeding, no matter where it happens in Russia or in another country or even an international arbitration, it's a complicated process and also costs a lot of nerves, and it is not in favor of the business, and it also contradicts the professional goals, because the more court cases we have, the more job we have. But I do hope that I will still have enough job without court proceedings. But if we go away from this goal, so the main objective is for the parties to agree before the court as the easiest way. If the parties don't manage to agree, which way is the most efficient way to resolve the case? I've been involved in this area for the last 30 years, and my opinion is still the same, no matter how difficult the situation can be with the Russian courts or with the courts in other countries, the most efficient way is actually the international arbitration. Within the international arbitration, I don't want to tell you that the international arbitration is the fastest way of dispute resolution. When arbitration was only intended in the Western countries, it was actually in the 15th or 16th century, especially when Russia didn't exist as a country. It was also the fastest way to resolve dispute, but in reality it's not the fastest way to resolve cases, but the most efficient one. Only within the international arbitration it is possible to consider and resolve all the issues that are important for the parties in order to protect their rights in a required way. Going to the examples out of my practice, I can tell you I do use only my own experience because I'm a practitioner. For example, the arbitration in Stockholm, where we represent the uranium monopoly from Russia. The company was called Techprom-Expo. It was a contractual dispute, but all the facts were complicated in that dispute, and they also accommodated some corporate transactions, and the main protection from the Techprom-Expo export was the idea that the claimant, it was a former Techprom-Export subsidiary, made a fraud. And can you also imagine where we can also develop this idea? We can, in our court, we can say it was a fraud. The investigation is on in America, the Switzerland, Russia. Let's stop the court proceeding because we need time, and we needed 1 year in order to collect the needed evidences. And we found these evidences in Switzerland and in the United States of America in order to prove that the fraud was real. And even due to the flexibility of the arbitration, because the tribunal consisted of leading professionals, one of the arbiters was the Russian guy, and we were tortured for a long time because we had to explain every single detail, and the hearing lasted for 2 years for this subject only, and they agreed to provide this 1 year time to us, so we managed to collect the evidences. It was in more than 20 volumes, and all tribunal listened to this evidence for 2 weeks, and then the tribunal decided that according to the Swedish contractual law, it wouldn't be not correct, and the tribunal used the provision about the fraud, that it wouldn't be incorrect to satisfy the claim, because the claimant did know about certain circumstances and the date of contract and at the moment of contract execution. And this experience allows us to make a conclusion, because it was just an example. Okay? Probably no other forum can allow us to develop these ideas so widely. Certainly the claim, 1 billion claim, was denied. Is it possible to have efficient dispute resolutions in our courts? I think the position is quite clear. We do work with our courts, and we have some positive trends, and this trends and changes in the judicial practice, especially in commercial courts, are quite important. I can only give you examples. The following example is about the fact how our court investigate and study into legislation of other countries. Quite often Russian courts we learn it in the other countries' law in a very fast way, and even only when the transaction is overloaded with international elements and the court has to evaluate and assess the legal standards not only from Russia but also from other countries. It is a catastrophe, and we won't get a good result in the Russian court. Probably it was a case between Bank of New York against the Russian Federal Custom Authority for $22 billion. I just want to tell you what happened when the international law provisions were identified. The civil RICO law was used here. This is a law about the corrupted and companies and our organizations, and we were representing the bank in this case. And one of the evidence was that the civil RICO is civil in America, but in Russia it requires to use the criminal law, especially use the criminal law of the United States, what is not possible within the court proceeding at the Russian commercial court. And I don't want to say the judge invited us to make such a procedure, but nobody promised us an easy life, so we had to work out evidences to support it with the opinion of the leading legal professionals from Russia. So the judge agreed to assess this American civil RICO law against the procedure that is normally implied within the international arbitration. We provided the opinion of the leading professionals, including one of the author of this RICO law, including opinions of 22 professionals from this area, and we had also from Russian universities. And the judge studied all these materials, and the judge agreed that the main professionals can be heard in court, and they were examined. It was a kind of cross-examination of this. It was a cross-examination of these professionals, and the developer of RICO law was tortured within 1 day at the Russian commercial court, and the judge estimated all his explanations correctly and made right conclusions. And estimated the evidences in the right way, because the other party was saying that the civil RICO is not a civil law in Russia. And the judge decided to agree on the dispute, and the dispute was finalized by such a friendly agreement between the parties. So we spent 2.5 years for this, and the bank spent $14.5 million for advocates instead of $22 billion as custom duties. if we want to identify those cases that are within the Russian Commercial Court jurisdiction, deals with an idea which is normally known as a non-convenience forum. Out of my practice, I can tell you that we had a lot of papers about it, and Tatiana Neshataya from the Supreme Commercial Court of Russia wrote about it, that the courts should also check the connection between the dispute and court, and if it is easier to consider to hold the certain court proceeding at another court, it should be done at another court. Even last year, within one of the dispute, we were quite happy how detailed the Court of Appeal realized this idea within our dispute. There were all the formalities about of identifying the jurisdiction of the commercial court, and the commercial courts refused to hold these court proceedings. And it was quite important that we got the audio recording of court proceedings. It's a very simple technical thing, but in practice it is very important for our job, because I can also give you an example about one of the cases that is quite fresh from the late 2011. In the Court of Appeal, we wanted to actually cancel on the whole tribunal, all the judges, and the situation was quite aggressive. And the Chief Justice refused to give this dispute to another judge. It was not denied by the parties. We provided this denial from our case once again, and we did it actually in the court hall, in the courtroom, that we actually we denied the whole set of judges. And I think it was the first time in my practice when the judge decided not to consider this denial application in the way it is actually stipulated in the legislation, and the minutes of court proceeding was done in a strange way. And it was stipulated that we provide this application after considering the case on the merits, but nobody who didn't doubt that we provided to file this application during the court proceeding. When we made the cassation application, the only thing that they helped us to prove that we were right, that it was a very significant breach made by the judge, that we filed this denial application, and the audio recording helped us to prove that our application was made on time. And I repeat this application 4 times. Then the judge also called the court execute, and we didn't make this application for the 5th time. But we also decided to have a certain theater play here. So this audio recording played an important role in order to apply to the Court of Cassation. Unfortunately, I don't know the result of this application to the Court of Cassation, because my whole team went to Queen Emmanuel Company, and this dispute remained in my previous legal firm. and probably I will get the results of this court proceeding at the Court of Cassation, how important which role the audio recording played there. These are quite good moments, and they also help to accept the courts in a serious way in order to overcome the trends when all these significant disputes considered are resolved abroad. And I'm a Russian lawyer. I want all these disputes to be resolved in Russia and not in other countries, not in BVI. However, the development of the judicial practice was not always good, and everybody knows about it. I don't want to repeat it. One of the unpleasant moments was the position of Supreme Commercial Court about the arbitrability of shareholder disputes. Some of these disputes cannot be resolved by commercial courts, but how this position was stipulated, that was a real shock for us. How can we have respect towards the Russian court system if such a sensitive question can be resolved in a very rough and simple way? And it doesn't help the courts and judicial system, so a lot of disputes are resolved abroad. In my presentation, I also have to give examples of disputes by other countries without any details, and I can give you an example of a case that could be also resolved in Russia, but the businessman decided to create a holding structure in a way that the assets are in Russia. These were just production facilities. However, on all the legal issues, all the legal relationships are regulated in other jurisdictions, in the offshore jurisdictions. And within this dispute, these are Cyprus, the BVI, and Jersey. There was a dispute. We also started the court proceedings in all these jurisdictions, and in the courts can work very fast, and the security was provided also quite fast, because the objective is very clear. If there is a corporate dispute, we need to freeze up the situation and understand who is guilty and who is not. And the courts also understand taking account the position of the BVI courts, and the BVI court takes into account the position of Cyprus court, but this dispute has not been resolved yet. We have to wait for the next 2 or 3 years, and if it gets resolved, we have a lot of technical legal moments, and I can also tell you something here, but it is not appropriate to disclose the details of this corporate dispute. Another dispute also has some corporate elements, a kind of shareholder dispute. This LCIA is dealing with this dispute, and there are a lot of several arbitration court proceedings for $2 billion, and we also got some security in Cyprus, and we also managed to cancel some of this security. And the arbiters they studied the legal position of each party very carefully, but if you went to the whole procedure, you understand why it is our Russian businessmen try to use LCIA as a dispute resolver and not the Russian commercial courts. We also represent several clients, and he said that he didn't even know what LCIA was, but he also is quite grateful to the lawyers who decided to include this arbitration clause and foresaw this LCAA as the arbiter and the client who believes in the very correct resolution of a dispute. Probably that's all what I wanted to tell. Thank you very much. Thank you very much for your presentation. Now
I'd like to give the floor to Igor Ignatyshin, who will speak on financing M&A deals. Thank you, the organizers, and those who have stayed here till now. The organizers asked me to introduce a kind of an economic aspect to the discussion and to tell you the trends of the Russian market of M&As and of the financing of the market. As far as the Russian market is concerned, we have already heard about the M&A trends and specific features, and in particular across the world. But the Russian market comprises about 100 deals a month, more than 100,000 deals a year, about $100,000 cost like last year, and the peak was in 2007 when we had about $120 billion worth. And starting with 2010, we're trying to reach that peak, but we are past that stage. There are a lot of privatization auctions, which is about 1/5 of all the deals. It's privatization auction where the government or the state through Gosimущество, through municipal authorities, implements its sale deals and in terms of cost, the state involvement is not large because they are rather small deals, because major assets have already been sold, and it happened long ago. The average cost of the deal is about 100 million. The Russian market is highly concentrated. We have about 10 to 15% of the deals, which amount to 80% of the cost of the volume. And the major deals last year actually provided for the entire cost. So if we have very few mega deals, then they will cover the costs of the market, and we would say that the market has been established. As to the role of the market in the country, so it's about 5% of GDP. And as compared to the peak values of the world markets, the number is 10 to 15% of the GDP. And the relative volumes of the market are comparable to Europe or the United States. 5 to 10% is a nominal volume for Europe. As to the information transparency of the deals, we can say the following. I'll skip some slides. The Russian market is closed, very closed in terms of information. It's not disclosed by the participants. And the number of the deals which provide the information on their cost amounts to 35% only, without counting privatization auctions. Altogether, there are 45% of the deals in which the parties of the deal don't disclose their sources of finances and other details. About 10% of the deals which we tracked are those assets which conceal their buyer, and about 40% are deals where the seller is not known. So we know about the deal, but we don't know the seller behind it. As to the consultants, about 2% of the deal are those which become known as far as their investment or legal consultants are concerned. As to the instruments used in the deals, altogether, we couldn't have overall statistics on the market because information is disclosed in very few cases. But mostly it's quite standard. It's banking credits, syndicated credits with foreign banks' participation, well, some other loans happening before or after the deal in order to cover the used resources and own the resources of the company or shareholders using IPO, for example, which is rather popular in words but none in practice. Another feature of the Russian market is an active part of the government. I have already said that the number of deals is about 20%, I think I mentioned. But they're minor deals in terms of costs. But on the other hand, there are very few major deals where the government is not involved directly or is involved through quasi-state companies. And it is a kind of a selling part. And according to 9 months figures, about 100 companies were sold and about 60 companies were bought. So in terms of numbers, we can say that the government is not so active. And if we consider the costs and values, then we'll see that it's just the other way around. It's 5 billion. 2011, it was like 08 or 09. It's 2011. It's very much different. And this year, we haven't had any major deals in the market. But I think that the trend has not been reversed. But we can hope for stabilization of the situation. As to financing proper, we tried to consider the deals with external financing, managing buyout, where buyers act as managers and managers use resources for buying out the packages of shares. And we considered what happened over the first quarter this year and last year. Last year, it's about 3% of the market in terms of numbers and 1% of the cost. And now 22 deals have taken place this quarter, this year. And unlike formerly, when we had a lot of questions as to the further crisis, in 2009, managers have become more active. These are insiders who, at their level, take decisions on whether it is worthwhile investing its enterprises, whether they believe in the prospects of the markets, and so on. In 2009, it became more active, and this was a sign that the market will restore itself. This happened in 2009, and the same may be repeated now. But we consider that this is a sign for the M&A market to grow further. And since last year, managers have become more active acquiring companies. And these deals, based on 100% acquisition at once, they acquire major companies. And the recent deals are with management buyout and external investors. is the deal for acquiring Siberusky Shin, the company called Cordiant at present. As to financing at large, we can say that financing is mostly used through the following scheme. The companies using leverage, they would rather use it for the object of acquisition, object of the deal. Either they used loans or bonds or any other sources. So I try to identify certain important things because the function of our company is studying the Russian market. So if you have questions as to the Russian market as large, perhaps you would rather do it, and I'll take your questions, because otherwise it's useless to give you information for this or last year. Thank you. Thank you, colleagues. So now your questions, please. You can put questions to anybody. And by way of beginning, I'd rather address my question to Valery, to Mark. One and the same question, that is, what are the drivers for competitiveness of the national legal system? What does it depend on? I have heard arguments in favor of or against certain legal systems. We considered them all around. For example, we heard the analysis of English system and why it should be commercial arbitration, not Russian arbitration, and so on, arbitration. So there are a lot of studies of the Russian legislation. So should we expect, should be waiting for certain transfer to the Russian legal system, a number of deals, whether it depends on the practice, on the actors of the market, or does it depend on the lawmakers and so on? Well, if you don't mind, I will give you an answer concerning Russia. In the first place, the attractiveness of a legal system depends on two major factors, that is, court precedents or prescribed law, which makes it possible for lawyers or parties to the deal to interpret it, and the predictability of court decisions. Concerning Russia, the first thing is rather developed, the former, and we are hopeful that all the amendments submitted by the president in early April to the State Duma, which will improve it, and the culture of law enforcement as well. But I do not call upon you to assess all the novelties as something that will happen this year, and it will become okay starting with September, let's say, when it will be adopted. So there should be some time of adaptation, and there should be a period of elaboration of the law enforcement or enforcement code of court decisions, so on, to facilitate the work, of course, without killing all the initiatives which are being introduced. I hope that the court or the judicial community will hear the former president, and which our president-elect has taken up. I hope that the lawyers, which are the leaders of this country at the moment, they won't give up this topic, and the judicial community working on it, understanding that it is vital for the development of the country and society at large, won't be as classical and formal in terms of enforcement, killing in the bud all the initiatives provided by smart people. It won't be fast, but still, you know that the first step is most important when you start traveling along the road. So let us wait for this and expect the best. The microphone is switched off. Speak into the microphone. The interpreter cannot translate anything because microphone is not used. Микрофон. Дайте ему микрофон. So perhaps you are right. But I'd rather delegate the answer to Ivan, who is a high-level, highly qualified specialist in the justice system. Ivan, would you answer it, please? Well, I regret to say that I didn't hear the statement because the microphone was switched off, but I understand the gist of it. Well, I won't be surprised. 15 years ago, I heard these statements at a very high level in the judicial system that our courts should accept all the cases, whether there are arbitration clauses or not. Well, so the thing is that I won't be surprised if it happens. Perhaps I will be disappointed because this is not for the first time that such things happen. I wouldn't be crying, but I would feel sorry because it's a pity that we are discussing it all the time. We're saying that the role of law should be enhanced, that we should live as the whole world is doing. But in practice, well, it's different. Perhaps 10 or 20 years later, as my colleagues, for example, said very optimistically, and that we should sit and wait, and then we will rejoice 20 years later. Perhaps we will use the same law because English law will be better understood than Russian law, because the M&A lawyers are using the same terminology as English law, and the international arbitration and the Russian courts use English terminology. And I didn't, well, myself, I am not using good Russian. I'm trying to invent Russian terms, but the English ones are very clear and acceptable. But I'm trying to find Russian terms, but this is life. We say that that Russian law should become more important, but what we are doing is somehow making it vice versa, and there are a lot of lawyers who feel it much easier to use English terms or terms from English law. Well, what can we do about it? Microphone, please. Микрофон дайте им, пожалуйста. So, a man should emerge who would develop new institutions. Do such men emerge? There's a provocation agreement. there's all convenience for them. A lot of things are in place in Russian law. That's why statements vary. 15 years ago, 20 years ago, they were different. All the time there are statements, and we are moving still in the right direction. Who would believe that we will have a system which will be similar to the European Union? And when they advised me, I thought that it was just illusion, but it has emerged already. And I think that 2018, 2020, well, it's far away, but I think that there will be a unification of the systems. And I think that a new civil Eurasian code will be developed. Whether it will be continental or English-like, it depends upon us. It will be accepted in 2018, and while in Russia new institutions emerged after a long struggle, okay, let us make the Eurasian Institute absolutely independent and free, and we'll have to apply it so we can advise upon it. We should not be crying. The process is irreversible. There will be liberalization for sure. There will be competition, and there will be development as well in the same direction, because scientific and technological progress and globalization forces all of us live together. But the ambitions of lawyers, that's another thing. And the statement we heard, it was just ambitious. And when I heard it, I thought that the president or prime minister should not be lawyers. That's the thing. We should do something about the lawyers' ambitions. They should not have the upper hand over law. And you are encountered with the same problem. So if you don't mind, perhaps you understood me correctly. I said I'm not going to cry in any case. And I did not cry when I heard the statement that we should accept all the cases, Tatiana Nikolaevna, but still we can use general statements speaking about the European Union, saying that there are requirements of the European Union. How will we survive? We will live in the United Europe. So, this does not help. We should be making actual steps, and we should be practical. If you don't mind, assessing the work of the judicial community, I think we should recognize, or admit rather, that though we are accustomed to a formal approach, sometimes we get, excellent solutions. For example, quite recently I got the ruling by the arbitration court number 12505, dealing with various issues of civil law, the issues of fairness of price and so on. It was beautifully worded, and I really got satisfaction reading it, as if it was written by the arbiters of the London arbitration court. They used the same terminology. They were very clear-cut, very specific. And this is what business would like to see when certain decisions are taken. But so far, we haven't seen many of them. And who was the presenter? Well, I haven't got the whole paper. It's just an extract. There are members of the Presidium, Mr. Vedryansky, Andreeva, Mrs. Andreeva, Vedryansky, and so on and so forth. Well, you can read it yourself. We agree with you. Well, the convergence of legal systems, globalization. Well, take a microphone, please. We cannot translate anything. I would rather support Valeri because I'm rather optimistic and believe that the developments will be fast, and we see that the judicial acts are of better qualities now, and this is what we discussed. The pace of decision-making, and there's predictability and legal developments, law is becoming transparent, global, and open, and we have unified approaches to settling the disputes and risk distribution. We have common standards. I think that very soon we'll have the same approaches, very close approaches to M&A deals. And I think that that will be a competition of prices, of schedules, and so on and so forth. We are young enough, perhaps we'll live to see it happen. Okay, colleagues, what do you think? If you have no more questions, I'd like to thank you for very fruitful work, and I'd like to thank our speakers, our presenters, those who attended the forum in order to make presentations. Thank you for very interesting presentations, and we appreciate your approaches and your positions, your presentations. I think it was interesting, and we didn't have any politicized or smooth over presentation. I think we had an interesting round table discussion, so I hope to see you next time at the forum.